Senator, it's good to see you again. Welcome back to The Source.
Hi, Pinky. Thank you for having me this morning.
Good.
Nice to see you again.
Yeah, there's a lot to talk about, especially you served as DOJ Secretary. I wanted to go through the process of this subpoena, which has been issued against suspended Bucor Chief Gerald Bantag, to which, what is this, Senator? Must he appear personally, or can this be done through his lawyer? The hearings are supposed to be set on November 23 and December 5.
Bantag must appear before the prosecutor because the counter affidavit, if he chooses to file one, must be sworn to before the prosecutor. And that requires presence. It cannot be done in any other way, unless, of course, the prosecutor will allow a video conference. And if that is allowed under the rules, I would not know. But certainly he must appear and swear to the allegations, to the truth of his counter affidavit, if he chooses to file one. Because, Pinky, he has the option of not filing a counter affidavit.
And not filing a counter affidavit would render what?
Well, not filing a counter affidavit would allow the prosecutor to assess the case on the basis alone of the evidence presented by the PNP and the NBI. That would be because there is no controversion on the part of the respondent. So if the prosecutor feels that there is a probable cause, he will file the corresponding information and case against Bantag.
Right, but would it be, Senator, would it be wise for the camp of any respondent not to submit a counter affidavit? Because doing that, not doing that rather, would basically remove or disallow you from defending yourself. Isn't that true?
There are cases where the respondent would choose not to file a counter affidavit because either they feel that the evidence of the prosecution is weak, and filing a counter affidavit will just expose their defenses when the case is filed in court.
I see.
So that is Bantag's call whether or not to file a counter affidavit. The consequence is that the prosecutor will now determine whether or not, on the basis of the evidence presented by the NBI and the PNP, a probable cause is established.
Yeah.
If there is probable cause, the risk and therefore the possibility of filing the case in court becomes a conclusion that.
Right. You mentioned, Senator, probable cause. It's important to note that because unlike what is supposed to happen when a case is filed in court and a verdict is about to be given, that is supposed to be proof beyond reasonable doubt. Ibang-iba po kasi yung probable cause sa prosecutor's office bago po magsampa ng kaso sa RTC. So this basically means, no, Senator, may makita lang silang konting posibleng ebidensya, pwede na po ito kasuhan sa korte.
Tama po yan. The existence of a probable cause simply means that a reasonable mind will conclude that the crime was probably committed, and therefore the court should hear the testimony and evidence of the prosecution and the defense of the accused. So that is the situation.
The serving of the subpoena, I also wanted to get your thoughts on this. This was supposed to be served in the last known address of the suspended Bucor chief, which is in Caloocan. Are you seeing any possible problems here in the event that the camp of General Bantag will say that they did not receive a copy of the subpoena? Or, Senator, would serving a subpoena in the last address be constituted as something that has been served? Or, dagdag ko na rin po, because it's all over media, can the camp of Bantag argue that they didn't receive the subpoena?
Yeah, okay. All those possibilities are there, but to say that he did not receive the subpoena is a little stretched because right now you're showing on the screen the subpoena,
Yeah.
and number two, under the rules, the National Prosecution Service and the courts would be correct in serving the subpoena in the last known address. And in this case, we assume that the address that is being specified is the address of Bantag appearing in the official records.
Okay. Would you care to give us your thoughts on that investigation by the PNP and the NBI, which subsequently, well, they filed a complaint against Bantag et al. Before the prosecutor's office? What are your thoughts on the evidence, on the statements made, on the diagram that was shown that eventually points, although admittedly by the Justice Department, no direct evidence kay Gerald Bantag, sir?
That's correct, Pinky. There is no direct evidence, and therefore the evidence is circumstantial. That's one. Number two, the evidence is principally oral testimony. I must confess, I have not seen the totality of the evidence, but from the newspaper reports, from the assertions of the Department of Justice, of the prosecutors themselves, or the investigators themselves, these are circumstantial evidence. I note the diagram that you said, that is not evidence. That is only trying to inform the public of the persons involved. Now, having said that, that the case for the prosecution is based on verbal and oral testimony and circumstantial evidence, we should emphasize that the possibility of retraction is always there, because you'll never know what will, if these people will retract, particularly anyone of the witnesses can retract, and that weakens theoretically the prosecution's case. Therefore, the prosecutor should look for corroborative evidence, meaning the evidence that will corroborate the oral testimony. And with this, this will strengthen the case. And should a retraction take place, the same can be discarded by the court because these are the circumstantial evidence is supported by corroborative evidence.
Understandable.
So that's the situation.
Well, the retraction,
yes.
When you talk about retraction, Senator, such as the case with former Senator Laila de Lima, a number of the supposed witnesses or those who testified, even before the House back then, had retracted their statements. Moving on, just a really quick one because I want to go to the confidential and intelligence funds. Senator Gerald Bantag said that if a warrant of arrest is issued against him, if a case is filed in court, hindi ho siya susuko hanggang nasa pwesto si DOJ Secretary Boying Remulla. I'm sure you're aware of the accusations of Gerald Bantag to the DOJ Secretary. What happens in a situation like this? Take, for example, he doesn't surrender if a case is filed in court and an arrest warrant is issued.
Well, Pinky, cardinal rule in evidence, flight is evidence of guilt. If he doesn't surrender, then that will be taken as evidence against him. Because I would repeat, a principle in evidence is that flight can be taken as evidence of guilt. So that is his own lookout. The duty of the prosecution and the law enforcement is to arrest him once and if a case is filed in court.
I understand that. That's all often been used, no, Senator? Yung flight is an indication of guilt. But if you talk to the other side, who would feel that I'm not going to get a fair trial here, could that flight serving as guilt, could that be interpreted in another way?
I don't know. No, that is the principal rule. It can be interpreted in another way. If he says, "I have not been properly served," or "I am not hiding," I'm not saying that there is no defense. What I'm just saying is that that can be taken as evidence of guilt, and
In
of course,
general.
the contrary evidence can be shown that there is no flight, that the
Okay.
evidence of guilt is not strong.
We will be taking